Hey all, Professor Tracy back with another lesson about the doctrine of consideration. This time we're looking at the pre-existing legal duty rule. So let's dive right in with an overview of the rule. It is kind of what it sounds like, that if somebody already has an existing legal duty, if they're already obligated to do something, then an alleged commitment or promise to do that same thing does not count as consideration. So if we're looking at this from the perspective of the promisee or from the promisor, it will fail, right? Because if it's the promisor, then they haven't in fact made a promise because they're already obligated or committed to do something. So their alleged promise isn't a commitment to do anything they're not already obligated to do. If we look at it from the perspective of the promisee, then the promise coming from the promisor hasn't in fact induced a new detriment, because we define detriment as the promisee incurring a legal obligation that they didn't have before. Well, if the promisee is already obligated to do something, then that can't possibly be a new detriment. So let's see how that works here with Barb and Bob giving us some help. Barb, what happened? Well, you do look a bit pale. I'm not sure, but I do know I need your help. Sure, Barb, anything. Wait, what's with the helmet? Oh, I joined the fire department. You what? Actually, that's perfect. It is? Absolutely. I was just going to ask if I can pay you $250 a week to make sure any fires in the area don't burn down my grocery store. So Barb is promising to pay Bob $250 a week and is looking to get from him a commitment back that he will ensure that no fires come near her grocery store. And Bob, being always happy to please, says, "Of course, I'd be happy to do it." And we're asking, is his seeming commitment here, what looks like a promise back to do this, is that in fact consideration for Barb's promise to pay him $250 a week? And the answer is kind of obvious based on what we said as the rule, that here the promisor is Barb. Barb's promise is to pay Bob $250 a week. Well, that's not inducing from Bob any kind of detriment. Why? Because as a fireman, he already has a public duty to protect buildings from fire as best he can. Obviously, it's not a guarantee, but he's doing the best that he can, and he's obligated, being that he's serving in a public role as a fireman. So it's not going to work here, right? That Barb's promise is not inducing a new detriment from Bob, and therefore there's not a bargain for exchange, and therefore there is not, in fact, consideration for Barb's promise to pay him $250 a week. So there are two different types of duties, and I mentioned public duty here, and the other would be a contractual duty, meaning that somebody already has a duty based on either a contract with the person at issue or because of some contract with a third party. And we'll look at examples of both of those in just a second. So with a public duty, that duty, it may come from the fact that the person is a public official. And by that, we don't necessarily mean something like a politician, that they're the mayor or the president or a congressman or a legislator. They could be serving in some other public role as a police officer, a school teacher, a firefighter, they're an administrator, that any of those public roles, those jobs, carries with it certain public duties, that a commitment to do those things which they are already obligated to do by virtue of their office would not be a detriment if we're talking about the promisee, or would not be a promise if we're talking about the promisor. And also, even as private parties, people have public duties, the chief among them being a promise to follow the law. So if I were to come to you and say, pay me $50 and I won't hit you in the face, well, if you were to go, sure, I'll pay you $50 not to do that, your promise to me to pay me $50 would not be incurring or inducing any detriment for me, because I'm already obligated by the law not to punch you in the face, not to commit a battery. So we would say in that case, and whether that duty is coming from the law or coming from the fact that the person is serving in a public role, there is in fact already a pre-existing legal duty, so there is no detriment if they're the promisee or if they're the promisor. They're not committing to do anything that they don't already have an obligation to do. So we can see an example here if we go back to what we led with this interaction between Barb and Bob, where Barb says, if I pay you $250 a week, will you make sure any fires in the area don't burn down my grocery store? And so we had a promise from Barb to Bob to pay $250 a week. And Bob responds, you bet, I'd be delighted to do it. And so he seems to be agreeing, seems to be promising back that he will pay, or not pay, but that he will watch over her grocery store to ensure that it doesn't burn down because of fire. And we said that because he's serving as a public official, he has a public duty, and that will not be consideration. So the other source, though, of a pre-existing legal duty could be a contract. So if the parties themselves already have a contract in place, or if one of the parties has a contract with a third party that obligates them to do whatever it is they're now seeming to promise, then that too would fall within the pre-existing legal duty rule. So we can look at an example, right? Again, the promise to do something you're already legally obligated to do because of some other contract would not work. So let's look at an example. Bob says, Barb, I know you agreed to mow my lawn on Friday for $20 already, but I'm really anxious about it getting done. I have a big party planned for Saturday and the lawn needs to look great. I'll pay you an additional $15 if you're sure to get the lawn mowed as agreed. So he's promising to pay Barb an additional $15, and they already have a contract in place, and Bob has acknowledged that. Barb says, really, Bob? You're such a dork. Fine. So she's agreeing to do what? Well, to mow the lawn. And so the thing about that is she already has a contract with Bob to mow the lawn. So she's not offering or promising to do anything she doesn't already have an obligation to do. So that's not going to work as consideration, right? That Bob's promise to pay an additional $15 is not in fact inducing any detriment from Barb the promisee, because by virtue of the existing contract, she already has a legal obligation to mow the lawn. So that would fail and there'd be no bargain for exchange and therefore no consideration. So let's look at another example here. And here we have Bob. Hello, Barb, are you here?
Hey.
Ah! Oh, hey, it's Bo.
Hi.
Bo, you can't be sneaking up on your contracts professor like that.
Sorry, Professor Bob. I just wanted to run a possible deal by you.
Oh, okay. Fire away then.
Professor, I will pay you $500 a week if you will teach me contracts every week for the next 8 months.
So Bo is promising to pay $500 a week to Bob to have him teach contracts for the next 8 months. So we have a promise from Bo to pay this money, and we have to ask, well, is there consideration for that? Is it a contractual promise, or is it a gratuitous promise? Is there consideration or not? I already have a contract with the law school. You know they pay me to teach you contracts, right?
I know, but I just want to make sure you do your job well.
Well, I'm not going to say no to extra money, so I'm in. So Bob is promising back to do something he's already obligated to do by virtue of a contract with the law school. So it's different from example 2, where the source of the duty was a contract between the same two parties, here the source of the legal duty is Bob's contract with the law school, so with a third party, but the result will be the same, that he has a pre-existing legal duty, so he's not incurring any new detriment. So we can look and say, again, that Bo, the promisor's promise to pay this $500 a week is not inducing any detriment from Bob, the promisee, so there's not a bargain for exchange. So whether the source of the legal duty is a public duty because the person is a public official, like a fireman, or they are a private individual who is bound by the law not to do certain things or compelled to do certain things by virtue of the law, or if the source of the duty is a contract between the same two parties, or there is a legal duty imposed on one of the parties by virtue of a contract with a third party, the pre-existing legal duty rule says there is not consideration because there is no new detriment if we're looking at it from the perspective of the promisee, or that there is not a promise to in the first place because the promisor would not be committing to do anything new. They're already obligated to do what it is they're allegedly promising to do. So that's it. We'll be back and looking at the pre-existing legal duty rule in the context of contract modifications and see how that plays out. Hope that's helpful. If it is, please like and subscribe, and we'll be back for more. Thanks for watching.